Honorable members, the floor is open for debate. I now call on the Territorial member, Honorable Carvin Malone.
Madam Speaker, I, as usual, wish to thank you for the opportunity to state my position related to this most appropriate motion before the House. I consider it an honor, and I am privileged to be a member of this House at this time. I would ask that you allow me the privilege of referring to my notes from time to time because, unlike other presentations, I was careful to record, to write most of what I wish to present so that it is actually concise in what we have to do. But I'll read first from a saying. The saying says that the eyes of the future are looking back at us, and they are praying for us to see beyond our own time. They are kneeling with hands clasped, that we might act with restraint, that we might leave room for a life that is destined to come. To protect what is wild is to protect what is gentle. One of the sayings I oft look back to. Madam Speaker, the 2022 Constitution Order Review Commission must be prepared to usher in a new approach in the relationship between Britain and the overseas territories in general and the Virgin Islands in particular. This new relationship must be rooted in the four fundamental principles of self-determination, mutual obligations and responsibilities, freedom for the Virgin Islands to run their own affairs to the greatest degree possible, and a firm commitment by the UK to assist and initially guide the Virgin Islands in their socio-economic and political development. This commitment would extend in times of natural disasters, pandemics, and acts of aggression or affront to the well-being of the Virgin Islands. Asserting one's right to explore and prepare for the benefits of future economic or political advancement, Madam Speaker, cannot and must not be viewed as an adversarial economic or political relationship. Indeed, it is a commitment made and agreed by all administrating authorities through the United Nations from as early as 1946 and legislated in the West Indies Act of 1962, and as the Premier has stated, later legislated when it comes to the Decolonization Committee. Madam Speaker, the 2007 Virgin Islands Constitution Order was laid before Parliament on the 14th of June 2007 and came into effect on the 15th of June 2007. The explanatory notes to this order in Council, and I quote, "This order establishes a new constitution for the Virgin Islands to replace the Constitution of 1976. The new constitution includes, for the first time, a chapter setting out the fundamental rights and freedoms of the individuals and provisions for their enforcement. It provides for a governor as Her Majesty's representative in the islands and for a premier and ministers who form a cabinet together with the Attorney General. It provides for an elected House of Assembly, which together with Her Majesty form the legislature. It will now be His Majesty form the legislature. the Eastern Caribbean Supreme Court will continue to have jurisdiction in the islands. Provision is made for a public service commission, a teaching service commission, a judicial and legal service commission, and a police service commission to provide advice on appointments to offices in these services. A new National Security Council is established, as is the Office of Director of Public Prosecution. Provisions is also made, Madam Speaker, for public finance, a complaints commissioner, and a register of interest. End of quote. I am prepared to state that these advances placed in the 2007 order were all deliberate steps taken to prepare the Virgin Islands for further economic and political advancement. In contrast, and extremely concerning, Madam Speaker, the 2022 number 627 Virgin Islands Constitution Interim Amendment Order 2022 was laid before Parliament on the 9th of June 2022. Paragraph 1, subsection 2 states that this order shall come into force and on such day as the governor, acting in his or her discretion, may appoint by proclamation published in the Gazette. Madam Speaker, the explanatory note in this interim amendment order in council reads, and I quote again, the order suspends certain provisions of the Constitution of the Virgin Islands, in particular, those relating to ministerial government and the House of Assembly. It vacates certain offices, including that of the Premier, and dissolves the House of Assembly. It makes temporary provision for the government of the Virgin Islands by the governor, who shall consult, except in prescribed circumstances, an advisory council, and may establish a consultative forum. This order is to expire 2 years after commencement, unless it is continued in force or is sooner revoked by a further order in council. End of quote. The note further states, Madam Speaker, and I quote again, an impact assessment has not been produced for this instrument as no significant impact on the United Kingdom's private, voluntary, or public sector is foreseen. End of quote. Madam Speaker, at the 12th sitting of the second session on the 4th House of Assembly, dated February 10th, July 2020, the immediate past Premier and Minister of Finance introduced, and the House of Assembly approved a motion that reads, and I quote, now therefore, be it resolved that the House of Assembly of the Virgin Islands has appointed the establishment of and the composition of the Constitutional Review Commission for the purpose of conducting a full review of the Virgin Islands Constitution Order 2007 with the terms of reference specified above. Madam Speaker, as presented on the order paper of this, the 6th sitting of the 4th session of the 4th House of Assembly, dated Thursday, 21st July, as you say, some weeks ago, the current Premier and Minister of Finance has introduced, and the House is being asked to debate and approve a motion that reads, "Now therefore, be it resolved that the House of Assembly of the Virgin Islands approve an increase in the composition of the Constitution Review Commission from 11 to 16 members, and to update an expansion of the terms of reference as specified above for the purpose of conducting a full review of the Virgin Islands Constitution, UK Statutory Instrument 2007, number 1678. Madam Speaker, let me just put in terms of information. Research says that there are two main forms in which the Constitution could exist. One is a codified Constitution. This is one that is contained in a single document, which is the single source of constitutional law in a state, a country, a nation, you may say. An uncodified constitution is a type of constitution where the fundamental rules often take the form of customs, of usage, of precedents, and a variety of statutes and legal instruments. The United Kingdom has an uncodified constitution. It vests ultimate authority in Parliament to make or unmake any law. Since there is no written constitution of the United Kingdom, any law passed by Parliament has the potential to be of constitutional significance, meaning that the authority for altering the United Kingdom Constitution ultimately lies with Parliament. Madam Speaker, allow me to introduce also the concept of the Utilitarian Principle. Madam Speaker, a utilitarian believes in the principle of the greatest good for the greatest number, an action which is taken for the good of all, if you may. It seems to be a case of being practically or morally correct without being buttressed by a codified constitution. And then there's the rule of law. Madam Speaker, the rule of law implies that every person is subject or subjected to the law. This includes persons who are lawmakers, law enforcement officers, and judges. It stands in contrast to tyranny or oligarchy, where the rulers are held above the law. Rule of law principles, Madam Speaker, are procedural in that the law must be the supreme law of the land, publicly declared, accountable to the law, fairness in the application of the law, separation of powers, participation in decision-making, legal certainty, avoidance of arbitrary rules, legal transparency, equality, equally enforced, and disputes settled by an independent judiciary. Madam Speaker, for the purpose of the Virgin Islands Constitution order, an order in council refers to regulations issued by the sovereign on the advice of the Privy Council. In modern practice, the Virgin Islands Constitution order amendments are issued only upon the advice of the minister in charge of the department concerned with the subject matter of the order, being responsible in Parliament for its contents. In the case of the Virgin Islands, the Foreign Secretary. In small language, Madam Speaker, as it relates to the Virgin Islands Constitution orders, on the advice of the Foreign Secretary to the Privy Council, the United Kingdom giveth, and the United Kingdom take it away. During my debate, you will hear me ask in this action, is this action constitutional? Is it unilateral, utilitarian, that is? Is it a unilateral act of Parliament, or does it comply to the rule of law? Simple questions on the surface. Madam Speaker, I have resolved to identify persons who are intent on structuring and developing ideas and plans for the best BVI that we can ever imagine. Yes, develop a one Virgin Islands agenda that transcends political and social biases, personal egos, religious boundaries, etc., etc., etc. And what better time than now? What better time than now, Madam Speaker, to now that we have so many news, NEW, so many new. A new British monarch, new UK Prime Minister, new UK Foreign Secretary, new UK Minister of Overseas Territories, new Virgin Islands Commission of Inquiry recommendations, new Virgin Islands Constitution Amendment Order, a new VI Premier, a new VI Government of National Unity, a new Speaker, a new opposition member, a new membership proposed for the Virgin Islands Constitution Review Commission, new terms of reference proposed for the VI Constitution Commission. The only thing missing is a people's-centered agenda. Madam Speaker, we have a lot of work to do. The challenge is to create concise, people-centered, well-articulated positions on issues of social development, economics, physical development, constitutional issues, judicial issues, human resource development, agriculture, farming, self-determination issues, religious issues, the specific concerns of each island in the chain. And that's only to name a few. Madam Speaker, these and other critical discussions must be addressed so that the path forward would be made abundantly clear, or as clear as possible. We cannot avoid the serious discussions any further. Serious discussion number one: whose Constitution Review Commission is it? Is it the people of the Virgin Islands? Is it cabinet? Is it the House of Assembly? Is it the governors? Or is it Sir Gary Hickenbottom, who, it could be concluded, was the sole judge and jury of a pre-structured commission of inquiry, report, and sets of recommendations? Madam Speaker, if it can be considered a people-centered Constitution Review Commission, there are additional terms of reference that the people of the Virgin Islands may wish to be specifically debated and decided. A, inclusion of a provision for referendum based on a two-thirds vote approval by the House of Assembly and a simple majority of the voting public. That's A. B, consideration for the development of a timeline for a referendum to decide on becoming a unitary, sovereign, democratic state as His Majesty, as head of state in the first instance, and the nomination and selection of a Virgin Islands national as Governor General. C, inclusion of a provision for recall of elected representatives based on two-thirds of the votes cast from over 50% of the registered voters in the representative's constituency. D, administration and responsibility of the civil service to be devolved to a ministry. E, inclusion of term limits constructed on a 3-skip-1 basis for membership to the House of Assembly. F, consider Anegada and Jocelyn Dyke becoming declared as districts 10 and 11 by reducing the number of at-large seats from 4 to 2. Expose the functionality of the 2 at-large representatives being selected as premier and deputy premier. That one caught the attention of everyone that read it. Discussion number 2, Madam Speaker, should all attempts be made to convince the newly appointed UK Foreign Secretary, Member of Parliament, the Honourable James Cleverly, to advise the Privy Council and the United Kingdom Parliament to revoke the Virgin Islands Constitution Interim Amendment Order 2022 number 627, which suspends certain provisions of the Constitution of the Virgin Islands, in particular those related to ministerial government and the House of Assembly. At best, Madam Speaker, it is challenging, if not unrealistic, for the people of the Virgin Islands to have free, open, and unabridged conversations in regards to a new constitution order with such a weapon pointed at them, such a guillotine, so to speak, looming over their heads. Do this or else. Madam Speaker, I wouldn't at this time go through my personal feeling about the Commission of Inquiry in terms of how it was set up, but I would say that I am on record in that commission of leaving a document which states that most of the recommendations that will come out of it, and this was left on the 12th of June 2021, so it was long before the recommendations came out, that most of the recommendations would be best suited for the Virgin Islands because it would put us in a position where the people of the Virgin Islands can begin to have confidence of governance of the Virgin Islands by Virgin Islanders. Certain aspects of it had gone out of the door. Madam Speaker, what I cannot accept is that all of the advances made by your people through the 52 years of since the Constitution has been been replaced in 1950. How many years are we talking? 72? 72. And the many years since ministerial government, all of what we had asked to do, that our people asked of our people, was done. In 1962, when the offer was made to go, I always call it semi-independent, our leaders, in my view, correctly said no, because we had to get ministerial government implemented first. We had to get our roads built first. We had to get our airports built first. We had to get our hospitals first. We had to get our schools first. We had to get our administration building first. We had to get all of what we enjoy. We've done it. In fact, we've done it so well that when we go for even assistance, Madam Speaker, for any funding from the perils of natural disasters, we're told we have done such a good job, you don't need our help. We're not giving you anything. You can do it yourself. You have big reserves. You have the ability to do this. So we are the only ones who feel as if we can't do this. You go for help, they tell you no. You're too rich to be poor. And we down here feeling, well, look, we can't do this. Madam Speaker, there's a serious discussion that have to be had. Serious discussion number 3. The 2007 Virgin Islands Constitution, from the very beginning of the formation of the Commission, was aimed at further preparing the Virgin Islands for self-determination. There seems to be a reversal of this goal, or in reality, there seems to be compliance to the philosophy that neither the UK or any of the overseas territories currently wish for further political autonomy of any kind or fashion. How else can this be determined than through the conduct of a referendum? The Special Committee on Decolonization, Madam Speaker, this committee for the implementation of the Declaration on the granting of independence to colonial countries and peoples, also known as the Special Committee on Decolonization, or the C24, to which the Premier have made many journeys, was established in 1961 by the United Nations General Assembly as its subsidiary organ devoted to the issue of decolonization pursuant to General Assembly Resolution 1654, Roman numeral 16 of 27 November 1961. In accordance with the General Assembly Resolution 1654, the C24 was mandated to examine the application of the Declaration on the granting of independence to colonial countries and peoples. General Assembly Resolution 54 of 14 December 1960, hereafter referred to as the Declaration, and number 2, to make suggestions and recommendations on the progress and extent of the implementation of the Declaration. The C24 commenced its work in 1962. The C24, Madam Speaker, annually reviews the list of non-self-governing territories to which the Declaration is applicable. It also hears statements from representatives of the non-self-governing territories at its annual sessions. It dispatches various missions to non-self-governing territories and annually organizes regional seminar. But then in 1986, there was a letter that was written by the United Kingdom mission to the United Nations by J.A. Thompson. It was on the 30th of January 1986. Madam Speaker, it says, "Dear Chairman," and I will read from paragraph 3 and paragraph 4. It says that the vast majority of the non-self-governing territories for which the United Kingdom was previously responsible have chosen and now enjoy independence. A small number, however, prefer to remain in close association with the United Kingdom. And although they are able to modify their choice at any time, it seems unlikely that any will do so in the near future. In these circumstances, the colonial era, as far as the United Nations and its remaining non-self-governing territories are concerned, is over, done, finished. I added those 2 words. There seems no need for the United Nations to devote time and resources to the special study of these territories' affair. United Nations to devote. This is of the committee. Accordingly, I am writing to let you know that my government, that is the UK government, have decided that the United Kingdom will henceforth not take part in the work of the Special Committee on Decolonization or its subcommittees. You and the other members of the Special Committee may rest assured that we will continue strictly to fulfill our responsibilities under the UN Charter towards our non-self-governing territories, particularly the responsibilities set out in Article 73. We shall also inform the Secretary General of any relevant political and constitutional developments in those territories. But for now, colonial era is done. Serious discussion must take place. Number 4, what preparations are required to facilitate sustainable socio-economic development and political advancement? It is my considered view, Madam Speaker, that the following questions must be raised and vigorously debated by our territory's strategic partners and by Virgin Islanders and belongers. These questions should include, but should not be limited to: are we now prepared to collectively decide what we want? B, are we prepared to clearly state what we do not want for the BVI? C, is it acceptable or correct for the United Kingdom to seek to impose its global Britain agenda on the people of the Virgin Islands as an overseas territories, whether subliminally or unilaterally? D, what do we desire from our continuing relationship with the United Kingdom as an overseas territory? E, should self-determination be actively pursued by the BVI at this time, in keeping with the UN mandate of decolonization of all non-self-governing territories by 2030? F, should closer relationships be forged with our 5 neighboring overseas territories of the United Kingdom? G, should our neighboring overseas territories seek to create a joint union of United Kingdom overseas territories as an independent body with the monarch as head of state? Should the Virgin Islands seek to forge closer political, economic, and social relationships with CARICOM states and other administrating powers? What are the vulnerabilities of our economic pillars, and how can they be addressed with the goal of strengthening and diversifying our economy? We must explore, Madam Speaker, other issues and must take them into consideration, have them debated, have them addressed at this critical time in our economic, political, and social evolvement or evolution as a people, with proper reflection of our history. Madam Speaker, these discussions and more are on the minds and lips of a number of persons and must be addressed. I shall seek the leave and approval of the House to include the additional 7 topics that I have stated above that were clearly and earlier cited. The United Kingdom seek to include their list from their COI report for consideration. The people of the Virgin Islands seek to include their list from conversations held by people throughout the territory. So I'm not sure as to the exact procedure, but what I'm saying is this, Madam Speaker. I have enlisted 6 of the particular provisions that we would like the Constitution Review Commission to consider in their deliberation when they go to the people of the Virgin Islands, and to have them specifically listed as main areas to be included and expanded in the motion that is currently on the floor. So, Madam Speaker, at this time, if it is that we can have a second to the motion to have those 7 issues amended or seeking to amend the motion that is on the floor, I would be quite pleased for anyone to be able to get up and to be able to have those done. If we need them repeated, I can do so, but I think that most folks there are in the record. And I'll see whether or not we have a second to that particular. Inclusion of a provision for referendum based on a 2/3 votes approved by the House of Assembly and a simple majority of the voting public. Consideration for the development of a timeline for a referendum to decide on becoming a unitary, sovereign, democratic state with His Majesty as head of state in the first instance, and the nomination and selection of a Virgin Islands national as Governor General, inclusion of a provision for recall of elected representatives based on the 2/3 of the votes cast from over 50% of the registered voters in the representative's constituency, administration and responsibility of the civil service to be devolved to a ministry, inclusion of term limits constructed on a 3-skip-1 basis for membership to the House of Assembly, considering Anegada and Jocelyn Dyke being declared as districts 10 and 11 by reducing the number of at-large seats from 4 to 2, hence avoiding increasing the number of membership in the House of Assembly from 13 to 15, and explore the functionality of 2 at-large representatives being selected as Premier and Deputy Premier. I wait with a bated breath for a second.
Well, at this time, I will interrupt you, Honorable
Sorry,
Member.
yeah.
I do believe for what you seek, which is an amendment to the motion, in accordance with Standing Order 34.3, we would have to be guided that such amendment be proposed at the close of this debate for this motion. But just before I put the question in respect of the motion. But what I'll do at this time, just to confirm that position, which I believe it to be, I will just take a brief recess, and then we will reconvene. This House is now in recess. Honorable members, the motion before the House concerning the establishment and composition of the Constitutional Review Commission has been moved and seconded. I note Territorial Member Honorable Carvin Malone.
Madam Speaker, as promised, I stand in accordance with Standing Order 34.3 to introduce a motion for an amendment to the motion on the floor. Madam Speaker, if I may.
Please proceed.
Whereas the House of Assembly has approved the formation of a Constitution Review Commission with membership in terms of reference at the 12th sitting of the second session of the 4th House of Assembly dated Friday, 10th July 2020.
I'm sorry to interrupt you, Honorable Member. I believe you say whereas the House, I believe it's whereas Cabinet. The House has not yet passed this motion.
No, this was done, the first one was done on the 12th sitting of the second session of the 4th House of Assembly.
Okay, my apologies. Continue.
Okay, so I'll start again.
Thank you.
Whereas the House of Assembly has approved the formation of a Constitution Review Commission with membership and terms of reference at the 12th sitting of the second house of the fourth House of Assembly, the third, right? The third House of Assembly, sorry, dated Friday, 10th July 2020, whereas a motion is currently before the House of Assembly to increase the membership and amend the terms of reference to the motion aforementioned, whereas the people of the Virgin Islands wish to have included in the new terms of reference issues related to the good governance of the Virgin Islands. Now, therefore, be it resolved that the original motion be amended to further expand the terms of reference by adding the following to the terms of reference as paragraph D, Roman numeral 11, to D, Roman numeral 17, as follows. 11. Whether a provision for referendum based on a 2/3 votes approval by the House of Assembly and a simple majority of the voting public should be considered. Roman numeral 12. Whether the development of a timetable or timeline for a referendum to decide on becoming a unitary, sovereign, democratic state with His Majesty as head of state in the first instance, and the nomination and selection of a Virgin Islands national as Governor General should be considered. Roman numeral 13. Whether a provision for recall of elected representatives based on 2/3 of the votes cast from over 50% of the registered voters in the representatives' constituency should be considered. Number 14, whether administration and responsibility of the civil service to be devolved to a ministry should be considered. Number 15, whether elected members to the House of Assembly should have term limits constructed based on 3 consecutive terms in elected office and not be considered for elected office for a 4th consecutive term. 16, whether Anegada and Jocelyn Dyke should be declared as districts 10 and 11, respectively, and elect their own representatives, thereby reducing the number of at-large seats from 4 to 2. And 17, whether the posts of Premier and Deputy Premier should be determined from the at-large candidacies. Madam Speaker, these are provisions which I had stated in the debate that should be reflective of what, at minimum, should be considered when looking at the Constitution review. We have heard and we have expressed all of what the Commission of Inquiry has recommended, some of them readily acceptable or accepted, and others of great concern. But yet, it was mentioned earlier that they still have to be decided by the people. And yes, in ordinary terms. But there is a document that I have which says the framework for implementation of the recommendations. And some of it we basically had to agree to because if we were going to avoid the consequences of not agreeing to them, then we would, in fact, be probably in a different position. And I'm hearing everyone say, well, it's a good thing we're not, and it is great. It's not good, it's great. the best thing that we're not. But at the end of the day, we made an agreement. Now, there are some documents that I have requested, and when we return here next Tuesday, some of them will be placed on the paper. We still don't have the report of the Withers Cox. We still don't have the affidavits in support of the Commission of Inquiry, the affidavit in support of the suspension I read earlier for the interim amendment order seeking to cancel parts of our Constitution. But we signed that the Cabinet and its members will express full public support for implementation of the individual COI report recommendations. We read that the members of Cabinet are committed to using the full term of the current House of Assembly to work on the implementation of the COI recommendations without proposing early elections. We agreed that the HOA will be responsible for passing all relevant legislations necessary for delivering reforms. Members will amend the standing orders as required to achieve this objective. We read also that the Government of National Unity is fully committed to expeditiously implementing all of the recommendations of the COI report, with the exception of suspension. And we read again that the Constitutional Review Commission presents a final report to the Premier and Governor by the 30th of June, 2023. I was deliberate in making sure that all during the day I read only from documents printed, so that even if the acquisitions were made, as they were spouted out here earlier by other members, that I am making up items, that they would have a factual base to it. And at a younger age, I would have gotten up still and tried to refute some of the stuff I heard here today. But the fact is that documents are here. These are documents that are in print, signed. Well, I didn't get the signed implementation framework agreement as yet, as I had requested again. But these are documents that are here. These are documents that we have. And I am saying that if it is that we agreed that these terms and references will be included, well, we already agreed it, so they will be. But I'm saying that the people of the Virgin Islands will also need to have some others introduced, debated, looked at. And this is what this simple exercise is all about. Madam Speaker, I see no room for dissension in most of these. There's some of them that folks readily have said they would not agree on. But most of them is the stuff that we would readily agree. Now, of course, there's an impediment. All depends on who the messenger is. But let's divorce the messenger from what is really being asked. So the night is fast spent. We will have it seconded and we'll have it agreed, and we will close out the House and come back next Tuesday. So I put the motion forward, Madam Speaker. Thank you very much.
I call on the Territorial member, Honorable Carvin Malone, to wrap up.
Madam Speaker, I'd love to thank the member for the third, for seconding, the Leader of the Opposition, for seconding the motion for the amendment to the motion currently on the floor. And they always say there is a silent majority. And no doubt, this is the case. So I look forward to the support of all members. And as I'm saying, these particular measures have to be put to the Constitution Review Commission to be taken to the people of the Virgin Islands. And if members feel that they don't merit being considered by the people, well, that's their prerogative. But I can see full support for these measures because they don't automatically go onto the recommendations. They don't make it to that particular stance. But if it is that they feel that any of these or all of these merit going to be considered by the Commission and taken to Anegada to Jocelyn Dyke, including all the islands in between, and taken on the internet and on social media and all of the other mediums necessary for review by the people. Let the people have their views. The Constitution Review Commission came here, they had their way. We could not say anything then, can't get any answers now, and the people are still without a voice. This is a chance for them to have their say. So I put it for the vote. Thank you.
Thank you. For ease, perhaps I can read each proposed amendment and take a vote that way. Honorable members, a motion has been moved for the following amendment to be included within the terms of reference: whether a provision for referendums based on a 2/3 vote, approval by the House of Assembly, and a simple majority of the vote in public should be considered. Those in favor? Those against? The noes have it. This amendment is defeated. Honorable members, the following amendment has been proposed to be included within the terms of reference: whether the development of a timeline for a referendum to decide on becoming a unitary sovereign democratic state with His Majesty as head of state in the first instance, and the nomination and selection of a Virgin Islands national as Governor General should be considered. Those in favor? Those against? Those against? The noes have it. This amendment is defeated. Honorable members, the following amendment has been proposed to be included within the terms of reference: whether a provision for recall of elected representatives based on a 2/3 of the votes cast from over 50% of the registered voters in the representatives' constituency should be considered. Those in favor?
Madam Speaker, I'm just rising for a point of clarity. I thought because the motion was moved, we would have the decision on the votes on the entire motion because he read the entire motion. So I'm trying to understand why we're going through each particular section of the motion. The motion was read in its entirety, so can we not just have a vote on the entire motion?
Well,
Please, if I may.
I was merely doing it for clarity in the event that certain provisions would have been more accepted than others. to. Thank you. Honorable Member, I do note your position, but given that I've already began in this manner, I prefer to conclude this particular way. Honorable Members, the following amendment has been proposed to be included in the terms of reference, whether administration or responsibility of the civil service to be devolved to a ministry should be considered. Those in favor? Those against? The noes have it. That amendment is defeated. Honorable Member, the following amendment has been proposed to be included in the terms of reference, whether elected members to the House of Assembly should have term limits constructed based on 3 consecutive terms in elected office and not be considered for elected office for a 4th consecutive term. Those in favor? Those against? The noes have it. This amendment is defeated. Honorable Members, the next amendment that has been proposed to be included within the terms of reference is whether Anegada and Just Van Dyke should be declared as districts 10 and 11 respectively and elect their own representative, thereby reducing the number of at-large seats from 4 to 2. Those in favor? Those against? The noes have it. This amendment is defeated. The final amendment that has been proposed to be included within the terms of reference is whether the post of premier and deputy premier should be determined from the at-large candidacy. Those in favor? Those against? I'm sorry, let me ask that again. Those in favor? Those against? The noes have it. The amendment has been defeated. Therefore, the motion has been defeated. Honorable Members, I will go back to the substantive motion at this time. And now ask for those in favor. Let me read the motion again. The motion before the House concerning the establishment and composition of the Constitutional Review Commission has been moved and seconded. Those in favor? Those against? The ayes have it. The motion has been passed.